All right, good afternoon. My name is Gries, and this is my colleague,
Shonda Morgan. Hi, everybody.
We are here from the claims department at PCH Mutual Insurance. You might be wondering why a claims department is here. And the simple truth is we in claims see things when things go wrong. We don't get a chance to see all the things you guys do well and do right, and I know that happens every day. And we really appreciate what you do and how you provide care to your residents. What we have found is that it's a great way to learn is to learn through mistakes. And we see sometimes mistakes, sometimes just defendable mistakes where people are unhappy, but that's why we're here as an insurance company. The practical side of things is if we can prevent a claim, it saves us a lot of money. These claims can cost, anywhere between $100,000 to $1 million, and there are jury verdict values for broken hips and wound cases that go well beyond $1 million. So we are very dedicated to preventing those things from happening from an economic point of view and from a personal point of view. There's nothing that makes us happier than being able to help you guys provide the good and necessary care and avoid claims. The three ways to do that, or what we're going to do instead of a traditional lecture format, is to do a mock deposition. Shonda is going to be our provider. She is actually Screen Actors Guild eligible. So she is going to step into the shoes of a provider who actually provided decent care to a resident in our scenario, our fictional scenario. And she is going to be in the hot seat though, because the resident did fall, did break her hip, and now she's being sued. So we want to move forward, and let me see if I can. So I am, just by way of background, I am an attorney. I practiced law for close to 20 years, and I defended these type of lawsuits in litigation scenarios. I've been to law school, I've read the books of civil procedure, but I found that the best way to show you guys what the litigation process is really about prior to going to court in the discovery phase is through this movie clip.
What's all that?
Trotta's files, all of them.
You stole his files?
I didn't steal his files. Listen to this. I'm just ready to finesse him. I'm starting to finesse him, right? I got him going. He offers to have his secretary copy everything for me.
That's very impressive finessing.
That's not all. He's letting us use his hunting cabin as soon as he gets back. It's in the woods, it's quiet, he sleeps like a baby when he's there.
Terrific. You're a hell of a bondo.
What's this? You, reading this book?
Yeah.
Do me a favor, okay? Don't read this book. Okay? Thank you very much.
All right. Don't you want to know why Trotta gave you his files?
I told you why already.
He has to. By law, you're entitled. It's called disclosure, you dickhead. He has to show you everything, otherwise it could be a mistrial. He has to give you a list of all his witnesses. You can talk to all his witnesses. He's not allowed any surprises. They didn't teach you that in law school either?
What we're about to do. You get to not just talk to the witnesses, you get to depose them under oath. And that means if you're ever sued, you will be deposed, which is not comfortable. It's no fun. You'll have a lawyer, you have our insurance, we provide you with an attorney. That attorney can't help you. You'll notice Shonda is sitting here alone. I am not Screen Actors Guild eligible, but I will be stepping into the role of plaintiff's attorney, which is a little bit of a jump. As I told you, I was on the defense, but not too much. So we're just going to kind of let this play out, and then when we're done, we'll answer your questions, and we'll see, maybe it'll show some of the mistakes or some of the things she could have done better. You ready?
Ready?
All right. So, Miss Morgan, you understand that you're being deposed today, correct?
Yes.
And you have just taken an oath stating that you are telling the truth.
Yes.
The person who administered the oath is the court reporter, who is here to write down everything you say, which will then be turned into a book to be used in trial of this matter.
Okay.
And you also understand that you are being videotaped, and this video can and will be used at trial.
Yes.
Please tell me your position at Happy Home AFH.
I am the owner, operator, and executive director.
And in Washington, we call that the provider. Is that correct?
Yes.
As the provider, do you oversee and audit residents' charts to ensure that all documentation is complete?
Well, we are not medical, so we don't have medical chart like nursing homes and hospitals. We don't have that type of documentation.
Well, as the executive director, is one of your responsibilities to ensure that the facility complies with all licensing requirements?
Yes.
So, you are familiar with the WACS, or the Washington Administrative Code, that specifically governs adult family homes?
I don't know them by heart, but I know you comply with them. You need to remain licensed, and we're in good standing.
Even though you are non-medical, you are required by WAC 388-7610-315 to keep records of the residents.
I guess so. I would have to look at it.
Well, let's look at it together. WAC 388-7610-315 requires that the adult family home create, maintain, and keep records for residents in the home where the resident lives and ensure that the records contain enough information so the home can provide the needed care and services to each resident, correct?
Yes, that is what it says.
And they must be in a format useful to the home, right?
Yes.
And they also need to be kept confidential, right?
Yes. Yes.
You not only have to keep these records, but you have to make sure that your staff has access to the parts of the residents' records needed by staff to provide care and services.
Yes.
Where are those records?
Well, we sent you everything we have, so you should have them all, except for the records we couldn't find. It's been a long time, and we keep the records in the home, but they get moved around. It's been a long time.
This incident happened 3 years ago now, correct?
Yes.
Okay. Well, we'll get back to that. Daisy Smith fell in your care.
Yes, she did.
In fact, she fell 3 times.
Yes.
And the 3rd time she fell and she broke her hip and she died.
Well, yes, I mean, she broke her hip and then went to rehab and then died 6 months later.
And by the way, just as an aside, that's how they talk. That's how the plaintiff's attorneys do it. Even though there was a lot of time between the broken hip and the death. But they will start trying to control a narrative and make it look worse than it seems. Well, what else do you remember about Daisy Smith?
Daisy, she was a pleasant lady who was often confused. When she first moved in, she would get agitated in the evenings. Her family told us she would calm down by looking at pictures of Cat on her telephone, so staff would do their best to find funny pictures and videos to share with her. At some point, that didn't calm her down anymore. She would sometimes forget to use her walker and would get frustrated when staff would remind her. My staff told me that she frequently needed to use the bathroom and needed assistance with that. It was very frequent, and staff was spilling at the end of the road.
So your staff complained that she needed to use the restroom?
They did not complain, but I remember she needed to use the restroom often, and we were dealing with that, and we let the family know.
Did you document that Ms. Smith frequently needed to use the bathroom?
I don't know that we wrote that down. It was just how she was, and it started happening more and more.
How did your staff know that she was having this issue if it wasn't written?
Well, we all knew. We just knew.
Can you tell me when it started?
No,
Can you tell me how frequently she had to go?
often.
Can you tell me if there was a pattern, like a specific time of day when it was worse?
Well, I'm sure my staff knew.
Would you describe this as a changing condition?
Well, eventually she needed more care, but it was gradual, so it wasn't obvious at the time.
If you had been documenting these frequent trips to the bathroom, wouldn't you have seen this pattern and been able to tell her family sooner, give more information to the doctor, and identify her fall risk?
Yes, that would have been helpful.
And in fact, you have a duty to keep enough records to provide needed care and services to the resident.
Yes,
That is pursuant to the Washington Administrative Code, correct?
yes, it is.
You also need to update the care plan when someone's needs change, correct?
Yes,
If Mrs. Smith was getting up more frequently, she needed more supervision, right?
yes, she did.
Was this in the care plan?
No, but we did it anyway.
But you did not comply with the Washington Administrative Code,
No,
and you got cited by the state for failing to update the care plan.
yes, we did.
Did you tell the family that Miss Smith was getting up to use the back restroom more frequently?
We text her daughter. We had extensive communication with her.
Do you have those texts?
No, my phone doesn't save text. Well, actually, I dropped it a year ago or so, and it got wet, and I replaced it, and it lost all my data.
So you did not save your records in a manner that could be easily provided to the state or saved for 3 years.
No, not the text.
And this was your only record of communication with the family?
Yes,
So you did not comply with the Washington Administrative Code.
I guess I didn't.
Ms. Smith fell on November 2nd, 2024, correct?
Yeah, I think that's the date, yes.
Did you produce an incident report to us documenting that fall?
No, she wasn't injured, so we didn't have to report it.
You mentioned earlier in this deposition that you needed to comply with the state regulations, correct? Or the Washington Administrative Code?
Yes, we follow regulations.
Then you know that WAC 38876-10220 states, the adult family home must keep a log of alleged or suspected incidents of abandonment, neglect, abuse, or financial exploitation. And 2, accidents or incidents affecting a resident's welfare. So even if there is no injury, you still need to log an accident or incident that affects a resident's welfare.
Yes.
Now, Ms. Smith fell again 2 weeks later, and then again exactly 1 month later on December 2nd. This fall started a pattern of behavior that could have been prevented if tracked.
Well, I don't know that is true. We knew about her risk and we were managing her as best as we could. We could not restrain her.
Well, we will never know if you could have prevented this fall by reviewing records and identifying the pattern, because you did not keep adequate records.
I guess so.
You were inspected by the state with regard to your care of Ms. Smith, correct?
Yes.
What was the result of that investigation?
They did not have an issue with the care we provided, but we did receive citations.
In fact, you were cited for not having an incident report for the fall on December 2nd. This was the fall with injury, correct?
Yes, we did that incident report and we reported appropriately, but a year later when the state came in, we couldn't find the report. We usually keep it in a folder in a desk drawer, but we must have put it aside or provided the state or the family with our only copy.
Additionally, you also could not find some of your notes, and there was no update to the care plan showing that Ms. Smith needed more supervision, correct?
If only we'd used CareChron or another online documentation system, we could have documented this information in one place and sent it to the state and to our insurance company or lawyers with just that one easy email. I wonder if I'd asked a question in Caregiver Connect, if any of my colleagues would have suggestions for helping me manage Ms. Smith and her family.
And Shonda just turned this into a ad for CareChron, which is a free member benefit for PCH Mutual Insurance, or or Synkwise, which has even more features, or any of the other online documentation services that are doing amazing things right now. As you can see, our fictional provider here, she did a lot of the right things. Like it's not that they were neglecting this resident in this scenario, but they were really, once there was an incident, they were really taken to task, and you could see, had they been keeping additional records, how things could have gone differently, and she would not likely be sitting there and being deposed. Shonda also just mentioned, what if I had Caregiver Connect? A lot of you, in order to win an iPad, signed up for Caregiver Connect, which is, it's really just an online chat room. It's completely anonymous. We don't know who you are, but if you have a resident, we say, okay, I got this resident, all of a sudden, can't calm her down, she's using the bathroom all the time, we're scared she's gonna fall. Anyone have suggestions? It's just a place for you guys to use your network. You guys know your residents, and you can really, you know the business, you know caregiving, you can reach out and help each other. So those are the two things she kind of mentioned, saying, if only I had this, and on the screen we have a screen grab of CareChron, where it's just a quick place where you can jot down a note. So we're going to jump back in to the deposition format to see how this could have gone a little bit better had the facility been really more on top of note taking. Hi, Ms. Morgan. We're back at your deposition, and we're going to redo this. Did you create an incident report when Ms. Smith fell on November 2nd?
Yes, I did.
Did you document her need for frequent trips to the bathroom thereafter?
Yes, we did.
Did you document this change in condition on her care plan?
Yes, we did, and we noted that she should update her primary care physician and her family. The primary care physician determined that frequent trips to the bathroom were due to anxiety. She increased her anxiety meds, and Ms. Smith never fell again.
When the family reported you to the state, were you able to respond appropriately?
Yes, with our online record-keeping system, CareChron, we were able to hit one button and send our consolidated records to the state and our insurance company.
Get a screen grab of that email. Maybe not. There we go. There's a screen grab of that quick email to the state and the insurance company. And as a plaintiff's attorney, I am wasting my time with this case. I'm going to let it go. There was no significant injury, and I'm going to have a talk with my client that this is not worth our time. So we'd like to open it up to questions. As we were going through this scenario, I kind of anticipated some, and I can answer the questions I anticipated, but I'd like to first see if anyone else has questions.
Okay, here we go. Okay, so this is the first time I've ever heard about reporting an incident to my insurance company. Is that a standard requirement with you or for all insurance companies? I really not heard that before.
The reporting it in the deposition, what we were talking about was actually reporting the injury to the state pursuant to the regulations. Now, your question is important. When do you report an incident to an insurance company? I think falls are inevitable, right? I don't think you need to report a fall, necessarily a fall, every fall you have to us. We're busy enough. But if you have any inkling claim that a family is upset about the care, and there is a significant injury, it is probably good to talk to us or, whoever you're insured with. If you're a PCH mutual insured, we actually have a hotline which is anonymous. So if you have a question about whether, if you have any sort of legal question, you can get 2-3 hours of legal advice anonymously through our hotline. And you can ask, is this something I should report? And oftentimes they'll say, oh yeah, you might need some help with insurance. That's why you have it. That's why we're here. We're happy to help. It's what we do. Or they might say, no, forget it. You're fine. You did everything right. That it's good to ask. So if you have that question, you have PCH, you can certainly use our hotline.
I had a client that went quote unquote AWOL, eloped, just because they went home with her son for a meal, and the son forgot to report that they weren't coming home, and then of course we couldn't find them, so we ended up having to make a whole report and everything, police, everything, the whole thing. And then our insurance rate went up. So I'm seeing, okay, you guys have insurance there, and we're letting you know when a person has a call, here goes our insurance rates.
So I don't know if you have insurance with us, but if I saw that, usually what happens is if somebody does report and they're doing all the right things and they're up for renewal, if I ever get a question, I will give my honest response, which is this provider's doing all the right things. These are the people we want. We've had people who've had claims that we put on our board of directors because they had a situation and they handled it completely appropriately, and we not only kept them on for insurance, but we put them on our board of directors or a member council. So it does not automatically raise your rates or get you non-renewed to have a claim or report an incident to us. I think there's one back there and there's one up here and there's a bunch. We'll try to get you all.
It's just a concern. So if you are going to be reporting things to the insurance, the reason I believe we are reporting to the state, so the state can come in and do an investigation and say if it was a neglect or it was just pure accident. So now, if we are going to be allowed or required to report to the insurance company may run away with it and do all kinds of judgment that they are not even maybe qualified to make a decision. So instead of, because for me it's much better for this, because when the insurance company renew our licenses, they go through the state and they find out what neglect or whatever we have done wrong. And I think that would be the proper venue because there's somebody there who is objectively analyzing the situation instead of reporting to someone who may not even be qualified to make a decision and may make a mountain out of a molehill, And that is very scary for us because now we're being put into a position where our insurance would go up without due process,
Well, and we do look at it carefully as far as whether we renew or typically there's not an increase in premium for claims. This year we have denied a lot of claims because they were not timely reported to us. So people are being sued for millions of dollars and they decided not to tell us about the claim. So they get a lawsuit in, six months later, they've renewed their insurance, they didn't report it in a timely manner pursuant to their policy, and now I'm in the terrible position of saying, you're in trouble, you need a lawyer, you're being sued, but we can't help you because you did not comply with your policy. You waited 6 months or a year after this significant incident, and you didn't let us know. That is not a position I ever want to see anybody in. We hate those denials. And so if you tell us, we can help you faster. And we had one member that had just this family that was so difficult. And everything they did, the family was reporting them, and they're just finally they called our hotline and said, what do we do? And they said, submit a claim. We hired them an attorney to help them through the process, to defend them with the state and to help evict this resident. They eventually got sued for defending it because it's a meritless lawsuit. But they paid their premium and they're getting the help that we provide. If they hadn't told us, it would be a bigger mess and there might not be coverage.
Hi. So I have been looking for the right insurance, and it seems like the easiest one to find is one that has coverage limits of like 500 and $1 million. And I'm not sure the exact terms, but something like that. Would you recommend, like, is that sufficient limits? Because I know it's the minimum. Would you recommend going above and beyond that? Is there, like, I've looked into a little bit of an umbrella insurance policy, but that would be with, like, personal State Farm agent, and then how would that interact? Where would that even be okay if there's, like, your insurance primarily, and then there's State Farm on top of that? It's kind of confusing, even just trying to frame the question, but the ultimate goal would be, like, in the future, when I do get sued, how do I position the insurance company such that they are more incentivized to protect me? Or is it just everything's good to go and you just make sure that you do the process?
So there's two questions there. The first one is, that's a question for your broker. Your limits, I think are dependent upon how much assets you need to protect. These cases can exceed $1 million, $2 million. You can get runaway jury verdicts because the damages are subjective. It's what someone's relationship with their mother worth, right? You can't put a price on that. Sometimes it's not much, sometimes it's 20 million. So, you really just need to talk to your broker and figure out what the best premium, best policy limits per your what you can financially deal with. On the claim side, if we get a claim, whether in Florida we've got a $50,000 limit policy, or whether we've got a $2 million limit, I do everything I can to get the claim resolved within limits. That is our job. I mean, we negotiate. That's what I've been doing since 2003 when I graduated law school. I negotiate these claims and pull them down as far as we possibly can. That's a lot of legal maneuvering, and I'll cry if I have to. So, once you're in claims, we will take care of you as best we can, whatever your limits.
Thank you. I'm going to walk over to the back here and get this hand, but while I'm walking, I was going to let you guys know that I did have an elopement that happened, and when I went to renew, there was no injury. She walked about 1.5 miles to the bank, which was devastating. I can't believe nobody that was driving could see that this was an odd thing, and my insurance did not want to renew me. Fortunately, my insurance broker knows me very well. I've been in business since 2007, and she went to bat for me, like really went to bat for me. And so she was able to continue our policy. Yes, it did go up, but not because of the elopement, just because of the higher cost of things. So I think it's really important for you to make sure you have a good, somebody that you can talk to, somebody that knows you. You want to know your insurance broker or company.
That's a great point, Karen. I love it. So my question is about documentation. We are in a place where most of us, English is not our primary language, and we have to document. We rely on our caregivers to document. It is required to know English. We've got that. But I can be honest that born and raised, and that the difference between there, and there is confusing, right? So semantics of language. So earlier in the presentation, when you were going back and forth, you guys were discussing documentation importance. It sounded like progress notes were important. And we've heard different things throughout the years. I've been doing this almost 30 years now.
and it was like less is more. Your care plan should cover you. You don't want to say too much unless it's asked for. And then the other thing that really is a key point that I hope that you can speak on is going to be text messaging. So I've also heard from legal groups in the past, text messages can get changed or falsified. Is that a legal standing document in a court of law? In this example, if I'm hearing right, this is something that happened in the past. We didn't know the family was going to sue. The family has a window where they can sue. How do I know what I'm supposed to keep for text messages or not? Cell phone plans change, you drop it in the water, whatever the scenario. So how are we printing text messages every chance we get them, and we're stamping them, and it's a simple signature in the corner, and we're throwing it in to the electronic system? And then we've got archaic DSHS. When you have an electronic system, they're not going to recognize that necessarily as a surefire way of having things, and they give you a hard time with it, right? And we have excellent programs, like stated, right? So it's like, talk to us, please, about what is good documentation, how to document, what would be called out in the court of law or for a deposition. Thank you for your time.
Sure, so it's tough, right? Because the Washington code says you just have to keep documents that allow you to provide proper care, right? Which doesn't give a whole lot of guidance on what that is. And in the scenario that we provided, a pattern did develop, but of course you don't know what pattern's going to develop when it first starts. Like, you can only see that in retrospect. So exactly how much you're supposed to write down is hard. But I think, the typical is you document by exception. So if something happens out of the ordinary, jotting it down is important. If you're going home at night, or you're walking around, you're making dinner, and you're still thinking about that resident and thinking, she really is getting up a lot. This is making me nervous. That's probably a good time to write it down, right? Like that's something sort of out of the ordinary. It's not an easy day, but it's hard. In any court of law, like I said, everything is discoverable. Everything is a legal document. You don't have to necessarily keep your texts, but if you don't have a record of the communication. So it's probably helpful to keep those, either print them or just have a phone service that keeps them. I don't always believe less is more. I think if you're doing the work and you're paying attention, it's going to help you in a multitude of ways. It'll certainly be able to help you defend yourself if you ever get in litigation. But it's also going to help you communicate with your staff. It's going to help you communicate with the family. And it's going to help you better understand your resident. I know, as caregivers, you're not people who are sitting in front of computers every day. You probably don't go into this field if you want to just sit and write about things. You actually want to be with people and provide the care, and that's very important. Technology is doing amazing things. Our CareChron, which is our free member benefit, doesn't have it yet. I'm pushing for it. Voice to text would be amazing. Carry around your phone and just talk in a note is probably the easiest way to do it. I know if you're in court, you get misspellings and you get messy notes, as long as it's readable, it doesn't matter. You can defend yourself. I have never seen it ever be an issue in a court where, something's spelled incorrectly, even in a lawyer's brief, by the way. It's just not relevant. So worrying about that level of detail should not be in your mind. Just make your point. And finally, I don't know if Synkwise does it, and CareChron is not there yet. CareChron's pretty basic, but if you just have a small home and want something simple, CareChron's great because it's simple. But there are quite a few online services that have a translate feature, where you can hit a button and it can go from Spanish to English or English to Spanish in seconds. It's amazing. I have gotten handwritten records in Spanish, and I'm just hitting my head against the wall. It's a French, and in high school, so we have to send them out and get someone to translate them. But it's okay. We've got the records. They did what they needed to do, and they did it in the language that they spoke and that people communicated in, which is spectacular. So, don't sweat it. Don't sweat the spelling. I mean, just make your point and provide your care.
Hi Laura, it's Laura, right?
Yeah, hey Tony.
Can you explain the difference between claims made and occurrence insurance, and can you also explain PCH's anonymous hotline that they can call so that people really understand that it is anonymous and you can't get advice without disclosing everything?
Yes, okay, so I said yes. Claims made and occurrence, it will make your head spin. Really, PCH's policy, claims made means that the claim is documented when it's reported. So if an incident happened a year ago and you didn't think it was a big deal, you didn't report it, but you call us today, under a claims made policy, the claim would be, documented as coming in today, September 26th, I think it is, of 2025. If you have an occurrence-based policy, then that claim would have been made under your prior policy year when the incident happened. If it was in our mock deposition that fell on December 2nd, 2024, under occurrence-based, that would come under your 2024 policy. Our PCH Mutuals policy, actually, the claim needs to be made within the policy year, so you need to be actively insured with us to call in a claim. And the occurrence needs to happen within your retroactive date, which can go back 5-10 years, but it needs to happen within an insurance period. It is a bit confusing. I think the sort of important takeaway, which is a callback to another question we had about reporting an incident, is for PCH, if you have an incident that could give rise to a claim, so if there's an accident that happens, someone gets hurt, and you're like, this could be bad for us. State gave us a citation, family's unhappy. You have to report that within 60 days. And if you don't, it could jeopardize your coverage. If you don't report it within the policy period and your policy renews, it will really jeopardize your coverage. And that's when it's like you're trying to balance, do I want to tell my insurance company about this? Yeah, because you have insurance because accidents happen and you might need coverage for them. As far as the hotline, Tony's follow-up question, that is the best place. If you have any question, is this something I should report? Call the hotline. That is anonymous. I don't know, no one from PCH knows, or PCALIC, the broker, underwriting team, they don't know who is calling that hotline. And you can get up to 2 hours of free legal advice. And that attorney can say, oh yeah, you better tell someone about this. You're in for it. You're gonna need an attorney, call PCH right away. Or they can talk you through a situation and say, you're okay with our 2 hours. But it is completely anonymous. And we do this because we want you guys to feel comfortable coming to us. Like I said, I do not like writing detailed legalese coverage letters that ultimately tells people they're in real trouble, and they didn't have to be in real trouble.
Also, I want to speak to having a traditional background insurance, hearing the negative tone as as it pertains to reporting claims. Where it's different for PCH Mutual Insurance is this is a mutual relationship. We're here for our members. So if there's a weird inkling about something that happened within your facility, we want you to report it as a precaution. It's not going to be held against you. And we're going to follow up every 90 days just to check to see if anything happened. We would rather do that than to be scurrying around a year later and hearing about it. Report the incident, send us your records and then let us worry about if it escalates or not. If they reach out to you, we'll hear about it. If they reach out to us first, you'll hear about it. But it's better, for us, it's not a negative thing to report a claim. It's better for you to report it as, you know, that whole intuition type of thing. Because you know how the family is feeling, you know how the communication went. Like, just don't sit on something like that. Just report it as a precaution.
Yeah, and we can't speak for other insurance companies. I don't know that it's the same situation with your auto insurance. I don't know if it's the same situation with your homeowners. It probably is not. We are a very small member-owned risk retention group, which means we don't operate for profit. We operate to break even for the benefit of the people who own the company, and the people who own the company are the people who are insured with us. So we operate very differently. Our advice is not for insurance across the board. I think that skepticism is potentially makes sense in some instances.
Yeah, it does.
But not others. I'm tired of denials. Any more questions?
Can you just talk about, does anybody else have any questions? I don't want to.
There's someone in the back.
Well, right there. So can you just talk about how do we decide our limits, our maxes? Like, I know the minimums that the state requires is 5 million, but my husband is a physician assistant, so we obviously have an umbrella policy as well, and we go a little bit more. I've always been told that, number one, there's a law that says if you are underinsured and you have a claim, that you're going to be in bigger trouble. And number two, do you base it on the value of what your assets are?
That is a broker question.
Okay.
In claims, look, I deal with what I have. But definitely ask your broker, because I think you're right. You want to protect your assets. That's one reason you have insurance.
Thank you.
You had mentioned a timeline of reporting a claim in order for it to be covered, about those denials. I'm wondering, is that timeline to report the initial incident or like a lawsuit? For example, if 6 months ago a resident fell and I didn't report it because I didn't think it was severe, and today I get sued for it, am I going to have a chance of getting denied because it happened 6 months ago, or am I covered because the lawsuit just happened?
So, first question is, if you have a lawsuit, report it immediately, because we don't have much time to respond. The second question is harder to answer. I think to be most cautious, like Shonda said, let us know. There are times when you will do everything right, and there's no way you would foresee a lawsuit. And in that instance, then it will probably be covered. It would likely be covered. But I'm seeing far too frequently that people knew, there was communication from a family, or certainly like you get cited by the state, then you have a problem, right? But just a fall with a hip fracture and a good relationship with the family and no obvious mistakes on behalf of you or your staff, then, in that instance, it's probably reasonable that you didn't foresee it. But there's no, with us, if you err on the side of caution and someone from underwriting says, Laura, what's going on? I say, these guys are great. They erred on the side of caution. They're paying attention and they're doing what they need to do. These are the people we want to insure.
Thank you.
I have a couple of questions. Can you explain to me what a high-risk retention group is?
So it's not called I don't know that there's anything called a high-risk retention group. We are a risk retention group, and when I just said we are owned by our members, we operate not for profit, and we are owned by our members. So that means we don't operate like some of the big insurance companies where they're trying to make money. Everybody who buys our insurance is a member and is, we don't say owner, but is a part of the company. If we have any excess at the end of the year, we put it into member benefits, which is why we offer the 2 free hours of legal advice, which is why we offer an online record-keeping platform. It's why we do why we come to conferences to do this kind of risk management. It funds videos, blogs, handouts, all to help you guys provide good care and prevent claims. We have a board of directors. We like to have, actually have a member who's a board member. Like I said, we've had board members who have had claims and they've done so well with the process that we put them on our board of directors. So it's member owned, it's member influenced, it's in some senses member operated insurance group. It's the purest form of insurance. You guys get together and pay your premiums to support each other if there's an accident. There's reinsurance too, in case we get something really rough. We're insured, so we can handle things.
That's good to know, because it was kind of referred as like an SR-22 for some, and I was like, I don't understand what that means, so thank you for that.
Sure.
Second question, if you have an incident in your little home, and I'm referring to a provider that had a situation where a resident had unlocked their wheelchair and was freely moving and fell, broke her ankle. Anyway, long story short, she called her insurance, I'm not sure which one it was, but they told her she could either hire her own attorney or they could represent her themselves. Well, she went with the insurance company and she was told the goal was just to settle out of court. So she didn't feel like they were really fighting for her to kind of fight the claim, and all the documentation was there. However, RCS decided to cite because even the resident had the right to move because they were on some, incline that the ground wasn't level enough. And anyway, do you fight for the provider? Do you fight the claim as much as you can, or is the goal just to get it over with, paid out, and be done?
Okay, so I spent most of my career as the lawyer who fought for the providers, and that is, of course, what I love to do. We will sometimes make an economic decision, and usually that decision is made because our ultimate goal is to protect our members, to protect the insured. So if there is any inkling that the case could exceed policy limits, then we need to settle that. We cannot, we do not want, I should say, every case plaintiff is going to tell me will exceed policy limits, and we fight like crazy. I tell them, no, they won't, and this is justifiable, we did nothing wrong in so many ways. But ultimately, we don't want our members exposed to expense beyond policy limits. And because damages in these cases are subjective, and because juries can get so mad that potentially, a helpless person was neglected, that the vast majority of these cases settle. And most of the time, our providers are happy with that. Defending yourself in a lawsuit, not fun. We gave you a little taste of it, but there's a lot of work involved. It pulls the providers away from providing their care. So most of the time, people were begging me to settle, and I'm like, wait, but you can be defended. Like, let me just make this argument for you, and let's get this down. We definitely listen. If providers have good defenses, we want to hear it, and we appreciate it.
Any other questions? I've been coming to a conference here every year for about 10 years, and I don't think we've ever done a mock disposition or depositions. So I appreciated that. I thought it was great. What did you guys all think?
Thank you.
Thank you. You're welcome. Thank you. Don't forget to sign in sheets. Sign in. And I think there is an auction, silent auction in the orca too. So.
And yeah, one last thing, meet us at our booth. The first, 3 people who sign up for CareChron, the online documentation system, get free Roho cushions. If you have residents you're sitting around too much, get them a Roho. And we have 2 more free Rohos for people who ask a question and caregiver connect. So we'll see you at the booth. Thank you.